Today programme on BBC Radio 4.
Our courts, our judges, should interpret our laws. That, for many who voted to leave the EU, is the simplest statement of what sovereignty really means. But like so many issues when it comes to Brexit, agreeing who will interpret the law after we leave isn't proving to be quite so simple in practice. Today, the government publishes its proposals on just that. In a moment, we'll hear from the Justice Minister. First, though, Ross Hawkins explains why the court, the ECJ, the court the Brexiteers love to hate, matters so much.
To really get to grips with the European Court of Justice, you need a bottle.
So creme de cassis is a blackcurrant liqueur. It's a French liqueur.
A barman like Gideon.
I thought we'd make a Parisian cocktail.
And a memory stretching back to 1979, when
the Germans had a state monopoly in alcohol, and to protect that, they adopted quite a few measures, some of which might appear a bit bizarre.
Peter Oliver, who worked in the European Commission back then. One bizarre German rule to protect their state monopoly meant that any cassis sold there had to have an alcohol content of at least 25%.
The French product didn't meet that requirement. It was between 15 and 20% alcohol. So the product could not be sold in Germany unless, of course, you added extra alcohol.
So French cassis could be kept off German shelves. The European Court of Justice decided that wasn't allowed, making using funny rules to keep out foreign goods much harder in future. But, says Theresa Withers, former Leave campaigner and cabinet minister, there was and is a catch.
The problem with being subject to ECJ rulings is it means that European law takes precedence over our laws here in the United Kingdom. And so if we are to implement the leave vote and respect the result of the referendum and take back control over making our own laws, we have to leave the jurisdiction of the European Court of Justice.
Entscheidungsersuchen des High Court of Justice of England and Wales.
Now British ministers will insist this courtroom in Luxembourg can't be the place Brexit disputes are settled. And yet many think will not escape its sway. Remain voting former Attorney General Dominic Raab.
The idea that we are somehow going to wholly escape the influence of the European Court of Justice on our lives in this country is, I'm afraid, pie in the sky. It's going to continue in many areas to have a very profound influence. But of course, the difference is going to be that we will no longer have any direct influence into the formation of that EU jurisprudence, because we ourselves will no longer be appearing in front of the ECJ as an EU member.
What influence could the court still have? Well, just listen.
And we're not leaving only to return to the jurisdiction of the European Court of Justice. And bring an end to the jurisdiction of the European Court of Justice in Britain. And bring an end to the jurisdiction of the European Court of Justice in Britain.
Theresa May repeatedly simply pledging to end the jurisdiction of the court. This morning, the government says it will end direct jurisdiction. No change, insist sources. The phrase has been used before, but in that extra word, opponents suspect a climb down. And perhaps a conclusion so much more complex than that cassis cocktail.
Quite fruity, quite blackcurranty, but nicely balanced, hopefully.
Now, lest all that talk of booze at breakfast time is making you feel a little bit fuzzy-headed, let's see if we can get some clarity from the Justice Minister, Dominic Raab, who joins us from Westminster. Morning to you.
Good morning.
Can we start with what the principle is here? What are you trying to achieve?
Well, Britain's leaving the EU, taking back control over our laws, and we'll be ending the jurisdiction of the European Court of Justice. But we're also forging a new relationship at the international level with our EU friends. And in any friendship, if it's to be strong, you need to be able to manage potential disagreements sensibly in the future. So how could we do that? Well, diplomatic channels can iron out minor creases relatively swiftly. On technical issues, you could use a subcommittee of experts on scientific questions of fact or sectoral issues. And ultimately,
but there will be a court.
Hold on. Ultimately, we may need some form of international arbitration. Now, we've looked very carefully at the global practice and also the EU's own practice with independent countries, which is the way it wants to treat us. And the way that typically might work, and I think is likely, is that the UK would appoint an arbitrator, the EU would appoint an arbitrator, they would agree a third, and that's how bones of contention will be settled.
OK,
now,
let's just for clarity,
just to be clear on the aim,
I want to be clear, if I may.
That's the way you make sure that the relationship goes from strength to strength.
OK, sorry, forgive me. I was only trying to pick up your words rather than butt in. International arbitration. It's an elegant word. It basically means a form of court. Call it a tribunal if you want, and it will involve judges, just to be clear.
No, fundamentally different. Arbitration is different from courts in lots of ways.
Will it involve judges? Will it involve judges?
No, it'll involve arbitrators, hence the name.
Lawyers?
Well, yeah, of course.
Lawyers, OK. And will there be foreign lawyers?
I've just explained, typically, we set this out in our position paper, we look at the global practice, but we also look at the EU's practice. The EU has never had an international agreement with any other country whereby disputes are settled by the ECJ. But of course...
I'm asking you what you want, though, if you wouldn't mind, Mr. Raab.
No, absolutely.
You want to have an arbitration panel, understood. That will be made up of lawyers. Some of those lawyers will be foreign, and those rules will affect us. Is that right?
Typically, the way international arbitration works, technical issue, but widespread practice for over 100 years, the EU has its own practice, we've looked at both, is that the UK would appoint an arbitrator, the EU would appoint an arbitrator, both sides might agree a third, and that's the balanced way, the cassis cocktail that your correspondent was talking about, that you make sure that both sides have got confidence in the process for managing disputes. That's the way the relationship goes from strength to strength. Now, that's one possible alternative, but I think it's the most likely.
OK, very helpful. Some might say, well, look, this in a way is still foreign. You don't want to call them judges. Let's call them arbitrators like you, foreign lawyers, foreign arbitrators in a form of foreign court making rulings that will have a direct impact on British people and business. And they'll go on and say, aha, that is why this word direct keeps cropping up now when the government says there will be no direct jurisdiction from that old court of justice in Luxembourg.
All this stuff, jingoistic stuff about foreign courts and foreign judges and lawyers is not ever language I've ever used, but we're absolutely clear.
You're not suggesting the people in the Leave campaign that you were part of. No, I won't hold on. Are you suggesting that people in the Leave campaign did not use the word foreign judges and foreign courts?
No, what I'm suggesting is that our commitment as a government since the referendum has been crystal clear. We're ending the jurisdiction of the European Court over disputes between the EU and the UK. That's not on the table. But look, let's also be clear about it. When we leave the EU, we're taking back control over our laws. There will be divergence between the case law of the EU and the UK. Sure. And it is precisely because there'll be that divergence as we take back control that it makes sense for the UK to keep half an eye on the case law of the EU and for the EU to keep half an eye on the case law of the UK.
But the former Attorney General, Dominic General...
Let me deal with Dominic's point. That's the way we manage disputes very sensibly
you
to make
remember
sure
what
the
he said.
relationship
I'm
goes
going to
from
remind
strength to
listeners
strength.
what he said.
Yeah.
Dominic Raab, the former Attorney General, said it was pie in the sky to say we will wholly escape the rulings of the European Court of Justice. The Telegraph newspaper, which, as you know, is a great cheerleader for Brexit, says it is quite likely in its coverage today that you would, in that arbitration panel, accept the rulings of the European Court of Justice. So I ask you again, is that why you have suddenly inserted the word direct, which was never used in the past, or not until very recently, into the promises you're making to the British people?
Well, no. Direct, all the direct means is that in relation to disputes between the UK and the EU, the jurisdiction of the European Court will not run. That the point I was trying to make to you is that, of course, precisely because UK law and EU law will diverge over time, both sides will want to keep half an eye on those differences to make sure we can manage it intelligently and sensibly. And I've looked very carefully at what Dominic Raab said, and of course his evidence to the House of Lords EU Committee in 2015. He pointed out that the Luxembourg court had predatory habits inimical to the UK, and that's precisely why we'll be ending its jurisdiction.
Keeping half an eye is one of those reassuring phrases that maybe doesn't capture what it means in practice, which is, in reality, isn't this the case? This tribunal may well say the European Court of Justice has made a ruling on this and we will abide by that ruling. We will respect that ruling, which will mean, to use the language used by many in the Leave campaign, that Britain will still be forced to go along with foreign judges in a foreign court.
No, that's absolutely and wholesale wrong. But what we would do as...
No, why? Why is it wrong?
Because I've explained, look, for professionals who've worked in this field, as I did for many years, arbitration is very clear. It is not about one side imposing its will on the other. It is about having a balanced process whereby both sides can have confidence. The UK Supreme Court, we wouldn't expect it to resolve disputes between the UK and the EU any more than we would accept
Just
the
one last one, if I could,
ECJ
please.
resolving disputes. But what you do is you manage the relationship, is keep half an eye on what the other side are doing. You take it into account.
Now, let me
promotes
just ask you a
dialogue.
direct question, because this word direct is getting a lot of attention from your critics.
Of course it is.
Prime Minister did not say direct jurisdiction in her party conference speech. The Prime Minister did not say direct jurisdiction in her January important speech on Brexit. The White Paper on Brexit did not use the words direct jurisdiction. There's a reason civil servants and politicians insert words, Mr. Raab, and many of your critics think the reason is you backed off.
No, absolutely not, and I've explained the difference. There'll be no jurisdiction of the European Court, any more than the UK Supreme Court, over disputes between the UK and the EU, but as a voluntary matter of practice, totally within our control, of course the UK will keep half an eye on what the EU does, just as the EU will keep half an eye on what the UK does. Why?
Keep half an eye on the
Because we
debates,
will
and thank you for
manage
joining us.
the relationship to avoid those creases and disputes getting out of control.